Senior Counsel Geoff Budlender, representing Advocate Billy Downer, has told justices at the Supreme Court of Appeal in Bloemfontein that from 2003, former President Jacob Zuma has played games to avoid prosecution in his criminal case.
Budlender says Zuma also always applied the so-called Stalingrad defense strategy.
Zuma is challenging the KwaZulu-Natal High Court ruling on his private prosecution. In June, Downer and journalist Karen Mourn won their application to set aside Zuma's private prosecution bid.
Downer has denied disclosing any confidential information about Zuma. Budlender argues that the ulterior motive behind Zuma's private prosecution is to remove Downer as a prosecutor in his case.
And let's stay with this particular story and speak to Mpumelelo Zikalala, legal analyst. Thank you so much for your time this evening. What are the prospects of success at the Supreme Court?
Mangat, good evening to you and also good evening to your viewers. Listening from what the judges were actually saying today and the number of arguments that were there, we can't whisk away the argument of saying that they may have the perception of saying that this is another Stalingrad activity. You may have the perception of them saying, why use this particular process when you can go and be prosecuted, but things may change. But from hearing from what they were hearing today, I do not think that the prospects of a former president are promising at this stage. Maybe if you go to the Constitutional Court, the Constitutional Court judges may come to another conclusion. But for now, I do not think that things are going in favor of the former president.
So I suppose then for you, it's not much of an argument that could hold water by his lawyers that there is insufficient evidence to support claims that any delays were caused by the former president and that the Pietermaritzburg High Court didn't investigate, in fact, the reasons behind any potential delays, but instead rushed to make a decision. So I suppose that argument for you does not hold water.
Even though the argument is very valid, but I must say this, that it may be the perception of the other justices that are there, because this particular case has been muddied by many other applications that are there. So it is not being looked at in its purity when it comes to whatever factors it must be concentrated on, because strictly speaking, whatever private prosecution which is taking place, legal avenue which is available to the former president is entitled to it. He can use it as any other individual can, and he must use it if he feels that he needs to do it. So if you are going to take one activity of saying that someone has broken the law, I've got a private prosecution certificate in which I'm utilizing at this particular moment, and that particular process is set aside, and in the reasoning that comes in, you then have within the judgment, a judge is going to say, well, you've come to court previously and stated the following things, and the court has made this previous ruling. I'm going to apply it to your matter. It is not fair in a sense that you can't use that in any of the judgments in which you have. So it may be that even though the SCA judges, when you listen to them, you could see that maybe they are not really convinced, which is why I'm pinning and saying maybe within the Constitutional Court, they would look at it with fresh eyes, the eyes of saying that at the end of the day, whatever judgment that you are going to deliver as a Constitutional Court is going to be binding on all the courts. Let's not muddy the waters by attaching other judgments that have been taken into place. Let's look at this matter on its own, and let's check whether there are merits, and if they are, let's check whether is it correct in terms of saying you can't really prosecute an individual even if you so believe that they've done wrong.
So is it then a case of a possibility then, as you say, of looking at this matter when it gets to the apex court, for example, should it get there, looking at it individually? Is that even a possibility? Because one could say all these matters are interlinked.
Strictly speaking, it must be looked at individually. You can't take things or certain matters which are taking place or being litigated by individual and lump it into one. You can't do that. You have to isolate each and every single matter that comes to you and say, what is the legal principle which is coming to me? What can I sue and how ought I should adjudicate on it? Because if you don't do that, you're going to create a very broad precedent of saying that whenever there's a certain litigant that goes to court, for example, Zuma, then it is automatically assumed that whatever that they're bringing is frivolous, is not supposed to be heard by any court. It is not supposed to be discussed or looked at in a matter in which you and I will be able to bring to court and should be adjudicated properly, which is why I keep on referring to the fact that the mere fact that in the arguments, in the judgments, there are going to be insinuations of saying that you are engaging in Stalingrad activities, you are doing things which are time delaying, that simply points to a presiding officer that has concluded that yes, it is a Stalingrad activity, and not looking at what that particular activity is there. they wouldn't have created a process of questioning legal processes and legal procedures if they did not think that that particular process was important to protect the legal interest and legal rights of an individual. So if a person says, I want to protect my legal rights and legal interest, you cannot then say this is a Stalingrad activity that you're engaging in. And the report, the manner in which you then correspond with the presiding officer, it sort of gives you an indication of saying that maybe this is a line of thinking that they are gravitating towards, and maybe this is how the judgment is going to be.
And I suppose then, even apart from fresh eyes, it may need some finality then at the apex court, I suppose.
Yeah, definitely. And it's a chance for the apex court to then say, because we are dealing with legal territory which has not been traversed as much as many others have, for example, when it comes to private prosecution, let's make sure that we're able to lay the ground rules and legal procedures that ought to be followed, so that if this matter were to crop up again, maybe in a few years to come, it is easy for a judge who's sitting within the Kaiserslautern division to then say, the Constitutional Court has given us guidelines and frames as to how these particular processes ought to be dealt with. Let's look at them in their entirety. Let's look at it independently and not blur the waters. What can't be denied is that there is an allegation of wrongdoing that has taken place. There's an allegation of contravention of the NPA that has taken place. But what we are finding now is, in certain instances, presiding officers sort of saying that we are going to shield you from the scrutiny of being investigated on that, so that you don't even go into the witness box and be able to bring or provide evidence, and make sure that all the evidence which is provided is through your affidavits. And then you then sit back and question, is it the correct method or correct manner of dealing with this matter? Coming back to an argument which I made maybe earlier on in the year, of saying that what ought to have been done was this matter not to be heard by civil court, but to be heard by a criminal court, because a criminal court would have systems in which they'll be able to scrutinize the truth from the lies and be able to make a determination at the end of the day.
It's going to be interesting to see how it all pans out, but thank you so much for that analysis. That is Mpumelelo Zikalala, legal analyst.